Okay. So we were at. Yes, please mute yourselves. Okay. Okay, so we were at the record and character of the applicant, wherein we were talking about the applicant's criminal record and his character and his good character in the books of the police officer. And usually, good character is taken where a respectable citizen in the society or in the locality that he lives in gives a statement on his behalf, saying, "Yeah, he's a nice person. He cannot do all of this." So the police basically, it's preferably, or the police prefers it to be someone who's old, and more often than not who is a male. It might be completely uh, unnecessary if you think, but um, people who are old, the women still have this thing of, oh, I can't talk this about this person, something will happen, and all of that. All of that is the mindset of the woman, but if the woman is willing to give, her statements are also recorded. But more often than not, the character or the behavior in society of a particular individual who might be arrested or who's asking for an anticipatory bail is taken from a respectable older man of the society, older as in someone who's crossed his 40s. Now, the strength of evidence, basically, the court may assess the strength of the evidence against the accused, as well as the evidence that accused provides. Now, the state basically will give certain evidences. When the state gets to know, it is given an opportunity to contradict that speech bail. If it is successfully able to do so, the accused's bail is completely cancelled. But if it does not do so on the date of hearing on the anticipatory bail, which is given as an interlocutory application, um, or which is given as just like an application to the court, when a case is ongoing and you want to take an anticipatory bail because you think you might be arrested, it is submitted as an interlocutory application. If before the case is even started, you want to apply for a bail, it is given as an application. Now, the strength of evidence is if the case of the applicant is weak, it may be a factor in favor of granting bail. Now, if the opposite person's evidence is not very strong or isn't appropriate or isn't enough, the court may be inclined to grant the anticipatory bail. Next is protection of complainant's rights. Um, the court must balance the right of the accused and the protection of complainant's rights. Conditions may be imposed to ensure complainant's security and cooperation. Now, the person who's given the complaint, uh, their rights also need to be protected, including the accused. Now, the accused might come to you as an advocate saying, "Oh, I've not done this," and even though it is not fair on the advocate's part to get to know that you've actually done something wrong once he starts arguing your case. Okay, because then his entire argument changes where he has to accept the fact that he made a mistake, because he can't say that you made a mistake, because then your sentence will increase and you will have to pay penalties and all of that. So his entire train of arguments completely change. So so if the advocate of the accused or the the legal representative, a person who represents legally, is informed that, okay, yes, he's done it, or no, he's not done it. Depending on that, their arguments may vary, and bail must also protect. If a bail is granted, the complainant's rights must also be protected. How is that done? By imposing certain conditions on the bail. The court may grant a bail, but they will attach a copy of certain conditions that need to be followed by the accused. Like some things that I have seen are that every week we need to come to the police office or the police station or the magistrate office. You need to sign, and you need to say that you're still here. This is something I have seen being done to a lot of people. Another incident that I can tell you is that do not go anywhere near the complainant's house. If found, you will not be granted bail, and your bail will be withdrawn and you will be arrested. That is another condition that is granted by that the court usually gives. The something that I have also observed, that I've further observed, is that anticipatory bail are usually with certain monetary compensation as well as a surety. So if the accused runs away, it is the surety who's going to get caught, and the surety is usually not a family member. He's a respectable citizen of the society. Can usually it is usually more often than not someone who is holding a place of authority. For example, company, sorry, the CAs. There are directors of companies. There are your MLAs, and in high profile cases, your MLAs give sureties. You have sometimes even people who are working as clerks being sureties, clerks of law firms, all of those also being as sureties. You have any person who's a major, who has a good character and who has no criminal record whatsoever, can be a surety for the accused. Now the complainant's rights are protected in that particular way. There's no, okay, so the next condition is no prior misuse of bail. Now, if he's a well-seasoned criminal, is what I'd like to call it. If he's a well-seasoned criminal, as in he's being taken bail multiple times, or he's asking for bail multiple times, and okay, so when all of that happens, and he has a history of misusing the bail, even though his evidence might be strong, he might have been granted bail on the direction of the court and all of that. If he has a history of misusing the bail need not be granted by um, the courts or the people in power. In public interest, if the court considers that granting a bail is against the public interest, it does not have to grant the bail. If the court thinks it is good for the public interest that they grant the bail, they grant. Public interest is usually the common ideal framework of the society, is what public interest is. These are not, so these are conditions where you can grant it, the court to grant. These are certain conditions followed by the court, and based on specific circumstances where bail can be granted or not granted. Now, this is something which you can read once I send you the PPTs. These are certain powers vested in the court for granting bail. I will not be going deep into this. Now, Section 437 empowers the court to grant bail for non-bailable offences. This section outlines the conditions under which bail can be granted, even for offences that are classified as non-bailable. There are certain key provisions which and the powers vested in the courts under Section 437. Number one is nature of offences: bailable or non-bailable, compoundable or non-compoundable, cognizable or non-cognizable, judicial discretion. Again, it's completely on the mindset of the judge, on the mindset of the court, on the mindset of the court hall. Thirdly, bail in non-bailable offences. For 437 clause 1 lays down circumstances under which bail can be granted for non-bailable offences. I would really suggest you read through the bail provisions of the CRPC to further enhance your knowledge. I will send you certain links of certain websites where you can go and you can read up more about it. Or I'll even send you the bare acts if that's what you want. Now, fourthly, there are certain conditions to grant a bail. The court imposes certain conditions, like the conditions I talked about in the previous slide. Those conditions are also imposed by the courts. Before granting bail in a non-bailable offense, the court must give the public prosecutor, like I told you, in the previous slide, that strength of evidence and protection of complainant's rights. Now, the public prosecutor basically works for the person who might be alleging an offense against you, as in me, the accused. If I'm the accused and one of y'all is a public prosecutor, before accepting my application, the court gives an opportunity to the public prosecutor for their side to be heard. Because while you're giving an anticipatory bail, usually only the accused side is heard. And we follow the principles of natural justice, wherein one of the key features of principle of natural justice is hearing both the sides. And you also give reasonable opportunity to be heard. Now, the prosecution presents its arguments against the grant of bail. Now then, here is when the battle starts between the public prosecutor and the accused and the defendant lawyer, wherein the public prosecutor is doing his very best. And public prosecutors are usually the best in their game. They know what they're doing. They usually have everything sorted. Like not as in everything sorted, as in all their arguments and train of thought, they are usually sorted, and they have a team of people working with them. And on the opposite hand, the accused, if the accused is able to hire or is able to pay for a really good lawyer, good enough. If not, the Aniket, please don't do that. Okay, yeah. So if the prosecution, so the prosecution is usually the person who is suing the accused. Guys, I can't keep telling this. Please don't touch your screens and please don't unmute yourselves. Okay, it's super distracting and I lose my train of thought. Okay. Okay, so a notice is given to the public prosecutor before granting a bail, and the public prosecutor is basically asked to come and present its case or their case before the presiding officer of the particular court hall or any judicial magistrate or sessions court or wherever the case is filed by the complainant. The complaint becomes a case once the FIR is filed. Now there is procedure which needs to be followed. That is not something I'd be discussing, but if you'd like to know, I wouldn't mind sending you my notes, but that is not something we want to discuss here. No, okay, so the prosecution presents its case, and then if the court is convinced with the prosecution, it will not grant bail to the accused. If it's not convinced with the prosecution, but it's convinced with the accused, they will grant a bail to the accused. That is how the game works. Okay. Right. So now anticipatory bail, 437 clause 3 deals with anticipatory bail, allowing a person to seek pre-arrest bail if they have reasonable belief that they might be arrested for non-bailable offense. Again, like I've already mentioned, even on this slide, which is section 438, then you have 437 clause 3, which also talks about anticipatory bail. The recording reasons is the next condition or is the next power which is vested with the courts, wherein the courts record the conditions and decisions and legal principles that they take into consideration before granting or not granting the bail. Now, section 437 clause 5 provides the option to the accused or the prosecution to appeal to a higher court if a bail is granted or refused by the lower court. Now, if I'm the accused and I've not been granted a bail, but my reasons are apt, and I think that the lower court or the sessions court, at least in the area that I live in, we have the sessions court and then we have the high court. There are some places where you have even GMFC, that's Judicial Magistrate First Class. You can always have different names, but these are certain things which is in Bangalore is what I know. So if I have applied for bail in the sessions court and the bail is not granted, but I think that I have good enough reasons, I appeal to the high court. After sessions court, the next court in power is the high court. But the high court's bail granting or not granting cannot be appealed in the Supreme. Supreme Court does not deal with bail matters unless it is in the public interest. Again, the Supreme Court is it already has a lot on its plate, right? So it can't be dealing with bail applications. So yeah, more often than not, this bail issue is usually solved within the High Court. And next, there are certain grounds for cancellation when the accused violates certain conditions or new evidence or information is found by the prosecution where they file an application under section 151 of CPC or under section something else of the CRPC, I'm not sure. But they file an application wherein they say that there is new information and new evidence which has come into picture, and this was only possible because the investigation is just now completed, and so they give an application to the court saying, hey, this is new evidence, I just found it, please take this into consideration and cancel the bail and get him back to jail. So that is new evidence information. Then you have, interference with witnesses. Now, another condition is that if the accused is found to be interfering with witnesses, or we all know, right? There's accused witness and prosecution, petitioner witness, respondent witness. So if the accused is basically found colluding with the witnesses of the complainant, his bail can be withdrawn. So colluding with the witness is considered as tampering with information or tampering with evidence. So that is why the bail is cancelled. And if the bail is misused and there's change in circumstances, these are all things that I've talked about in the previous slide as well, the bail can be cancelled. Now, the procedure for cancellation of application bail, again, it's filing an application. There's a notice which is given to the accused. There's a hearing when the accused also comes in before the court, and the prosecution is also there. The public prosecutor is there. And then you have the judicial discretion where they record the reasons, they give opportunity to both of them to be, argue against each other. And if anyone's not satisfied with the, if anyone is not satisfied with the grant or the not grant or the cancelling or non-cancelling of the bail, they can appeal to a higher court. Okay, so there are certain circumstances where anticipatory bail cannot be filed. Now, these are certain conditions. You have bailable offenses. Anticipatory bail cannot be filed for bailable offenses, non-cognizable offenses. Bails cannot be filed for non-cognizable offenses, as he's already arrested. So the accused, once he is arrested, he cannot apply for anticipatory bail. He has to apply for a regular bail or an interim bail. So there's no apprehension for interest. I just can't go, even though I have no evidence or nothing, I can't go and apply for an anticipatory bail. I need to have reasons, I need to have evidence supporting me. All of that is when, like you don't need to file an anticipatory bail. Now there's filing for delayed cases. There is abuse of process, there is conviction, there is suppression of information, there's frivolous and vague grounds. There are fugitives and absconders, there are serious and heinous offenses like rapes and murders, or serial killers who have not been granted anticipatory bail. They have to file for a regular bail. The process is even more hectic than it is for anticipatory bail. There's non-cooperation for investigation, like all of these are where if the applicant has already applied for bail, these are reasons which the bail can also be cancelled for, or it doesn't even need to be filed, right? Now, the contents of a bail application. This is where you need to focus, you need to take notes if you need to. Otherwise, I'll also be sending you the slides regardless. Now, there are certain contents of the bail application, right? So, one second. Okay, so title of the application is the first content, wherein you mention that it is an anticipatory bail application clearly. Anticipatory bail application under section 438 of the Criminal Procedure Code 1973. That needs to be there. That needs to be the, after you write the court and your CC number, CC's criminal complaint number, then you write your short title of the case, you need to mention the, so as in your notice, how you mentioned your subject, like that, the same thing you need to mention title of the application. You need to mention the code details. Code details comes even before the title of the application. Then you have details of the applicant, which is your first point number 1. Then you have details of the offenses, which is your point 2, 3, 4, accordingly. So the details of the applicant include their full name, their address, their age, their occupation, and their contact information. And details of any previous criminal record if they have it. And then you have details of the offenses. You provide a brief description of the offense which the anticipatory bail is sought for. And you also need to specify the sections of the Indian Penal Code or any other relevant laws which is given under which the applicant is accused. So under which I have been accused and I am applying for application. Thirdly, there are grounds for anticipatory bail. You need to explain reasons, proper reasoning you need to give to the court saying, hey, this is this. So This is reason number one. You explain the reason. Next point, reason number two, you explain the reasons. That's how you usually go. So you write, for example, was not at the place of the crime on the date of the crime, colon, and you mention your reasons. You give your evidences. You make it in one full big paragraph. In notices, your paragraphs need to be short, sweet, and to the point. But in bail applications, because you're giving your reasons, you're giving defense on your behalf. You usually it needs to be very, 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 very in detail. It needs to be meticulous, well thought about, well gone through, all of that. Now, statement of facts. These are usually mentioned just after the details of the offenses, before you give the grounds for anticipatory bail. Just a small brief, like, okay, just like in 2 or 3 points, you need to finish your entire statement. Statement of facts are usually a clear, concise, or sorry. Statement of facts are usually written after the grounds for anticipatory bail or before. I will clear that out. You just give me some time. Statement of facts are usually a precise, small, well thought out, super clear narrative of events leading up to the filing of the application. It includes information about any involvement of the applicant in the alleged offense or incident. For example, if I have a friend and she asked me to drop her somewhere, I have gone and dropped her there. She's murdered someone there. And then I am caught because I have been seen leaving that house, right? She is not found. So who will I catch next? Me, because I dropped her there. That also needs to be mentioned in your statement of facts, right? Then you have precautions taken. Any steps or any precautions which are taken, such as responding to summons or notices from law enforcement agencies. You've already informed multiple times when summons are issued. You've informed when you have notices sent to you by the the public prosecutor's office. You've responded to all of them. So those are precautions that are already taken by you. Then you need, again, I've mentioned it twice. I am sorry. These are already reasoning that you need to be mentioning when you're taking an anticipatory bail. So it might be a different thing if you don't want the grounds to be super, super long. Reasons for granting anticipatory bail is explained why the applicant deserves protection from arrest, emphasizing factors such as the applicant's clean record, his cooperation with authorities, he is a very good and respectable citizen of the society, all of that. And here you need to write relevant legal provisions, your sections, your what the section says and how you can interpret it, all of that need to be mentioned in your legal arguments. Now you have a list of proposed conditions. So your advocate, as a defendant advocate, he can suggest certain conditions, or you yourself, because the lawyer is representing you. So if you think, so if you want an anticipatory bail, basically you need to also propose conditions that, okay, I will not leave the vicinity of my house for 3 days until the investigation is complete, or I will not go out of the country until the investigation is complete. I will not be going anywhere near the complainant, or I will not be having any kind of contact with the complainant until the investigation is complete and we meet before. All of that are or proposed conditions that you can give to the court to take into consideration to attach to your anticipatory bail where the bail is granted to you. Now there is prayer and relief sought, wherein you need to clearly state the relief. Certain examples can be to prevent the police officials from coming to my house because I have kids. Like older people can do that. Now, then you can mention, in case the anticipatory bail is granted, rupees 15,000 fine for mental and physical abuse. That can also be relief. That relief is usually not granted because you might have gone through mental trauma, but the complainant is also going through a lot. that relief is usually not granted, but it's obviously always mentioned. Monetary value is mentioned for everything, so it does not matter. You need to still add it. The court, sometimes the mindset of the judge might twist a little bit and he might grant it to you. Then you have verification and affidavit. I will be teaching you how to do this. Verification is basically you're verifying that you are the particular individual you're stating that you are. Affidavit is usually for and Karthik, please mute yourself. Okay. Affidavit is basically you're again stating the same thing, that I am the accused in the particular case. I am well conversant with the facts of the case. I know that this is what is written. So verification is like a brief. Affidavit is elaborating that. That is all there is to it. And extras are like certain, for example, you were not in town on the date of the commission of the offense. You have a plane ticket to prove that. An extra. Jurisdiction, you need to mention that the particular court has jurisdiction over this particular that it is in the jurisdiction. Jurisdiction basically means locality. So if I want to apply for an anticipatory bail application, my first go-to would be the because I live at the very center. So this is just an example. I live at the very center, and my authority would be probably the sessions court, which is nearby the high court, right? So the high court is usually the center. It is usually around the legislature, and the judiciary in Bangalore is very it's like running on parallel roads like this. So that the fact that I am in the jurisdiction of the particular court, they have the authority to give me an anticipatory bail or not. That is what jurisdiction is. Your index is basically, this is usually written like right before you start your title. Okay, so you need to mention the court, you need to mention the complaint number, short title, index in bold, underlined, and then you need to make a table, serial number, particulars, page number. Right, serial numbers, what, like for example, you have application under section blah 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 of the CRPC. Next, you have annexures, annexure 1, annexure 2, annexure 3, annexure 4, page number 1, page number 2, page number 3, page number 4. That is, this is just so that the job of the court is easy. It is made easy. It does not have to, if like there are certain bail applications which are like thick, and the court doesn't need to go through everything to find where what is. You have an index, it's easier for the court. And there are certain offices, even though the application is just 3 pages, we still add an index. At least the place I'm working at, we still add an index. So it's easier for the court. It's easily navigated. You can easily navigate because the judge goes through multiple cases a day, and he's obviously exhausted. By the time the first case is over, he's already exhausted because the profession is just like that. So to make the job of the judge easier, to make sure he does not have to, if you're stating certain points, he does not have to flip pages to figure out where point is. So anytime if you ever see an advocate arguing, he usually says page number 4 of the application in the anticipatory bail. My lord, please turn to page number 4 of the application which is produced before you, and then they turn quickly. And it is just so that the job of the judge is easier. And if I just go say point number 4, he'll be like, where is the point, right? So in all of these certain small things we do to make the job of the judge easier, an index is one of them. Okay, now moving on with your task. So we have 5 minutes. I just want a consensus as to, I will just 1 minute.